let's get into this with two caveats. The first one being that I can only speak about what happens in the UK courts, specifically England, Wales or Northern Ireland, and you may be Canadian with a username like that. And the second one, what are the nature of the allegations or the findings against you? Okay, so when allegations are made, the court can do a number of different things. It can ignore them, and it does, because it knows that people lie left, right and centre. Lies are very common. I think just about every hearing I've ever done, every case I've ever done, there have been some kind of allegations of abuse. The court can ask you about them in a hearing, or ask you to address them in a statement, or it can order a fact-finding hearing. For your part, unless the court really wants to know what's going on, you just simply say they didn't happen and move on. Don't waste your time fighting allegations. So they didn't happen. If you're going to address allegations left, right and centre, you are effectively trying to punch smoke. You're wasting your time and your energy, and I promise you, you'll never get anywhere. And you're there in a family court not to fight allegations, you're there for your children. So there's that. So if there is a fact-finding hearing, it's basically a trial. The court can find that they can find allegations against you to be more likely to have happened than not happened, or vice versa. Not the same as a innocent or guilty thing. Remember, we're talking about a family court here, which is a civil court, so the burden of proof is a balance of probabilities. It's not like a criminal court where it's beyond reasonable doubt. That means there's a much lower burden threshold when it comes to it. So it's quite possible that the court decides, based on what it has in front of it, that something happens even if there isn't direct evidence. And I've seen this happen. I've seen people who categorically have had findings against them that aren't appropriate, and that leads to the next part of it. What do you do about it? And this comes the tricky part. So let me give you a scenario. Someone's accused of domestic abuse, and a finding is made against them, and they now have the court saying, you've got a finding of abuse against you, and we need to take some kind of action to act in your children's best interest, to deal with it, to get out of the way. Let's imagine that you've been told you need to attend a perpetrator's course to deal with it, and when you get on that perpetrator's course, you are expected to show insight. You are expected to accept the court's decision. And like I say, if you've not done this, you've got a dilemma. You can absolutely dig your heels in and say, I don't accept the court's findings, and I see people that do that all the time. And the usual approach of the court when that happens is that the court will say something along the lines of, okay, well, you don't show insight, we can't really move forward, there's going to be no contact with the children until that happens. I've seen this happen, and there's a stalemate. The court will happily let there be a stalemate. If you're in that scenario and you dig your heels in, eventually the court may even close the case down without any order for contact, and you're stuck. When it comes to fact-finding hearings and false allegations, people make allegations because, let's be honest, if you're denying a child a relationship with a parent, and the parent's a good parent, you've got to justify this. If you say something along the lines of, I don't want contact to take place, and you've got no good reason, well, it's not a very good look, is it? My experience over the years is that if you attend a fact-finding hearing, and whether there are findings made against you or not, if you deal with it in a positive manner, the most your ex is ever going to do is delay things. That's if you accept the findings of the court, one or the other. They'll delay things, definitely, but they won't stop it. And even if you have findings made against you, which are quite serious, because the allegations can range from really inconsequential to really serious stuff, contact can take place. The key here is insight. The key is to see that what you've done is wrong, like I say, You may not agree that you've done anything wrong, but the key is insight. Say you've done something wrong, hold your hands up, address it and move on. I see people complaining on this TikTok about how the court is not interested in history, and there's a balance here. The court is and it isn't interested in history. It needs to consider under the welfare checklist the impact of previous incidents, history, but the court also wants to move forward, because there's only so many times someone can shout he or she did that way back. It's got to end at some point, and insight is the absolute key here. So yeah, this is a really long and rambling post about fact finding. I'll probably find that no one's getting to the end of this, but if you are staring down the barrel of a gun of a fact finding hearing or allegations, that's pretty much how it goes. The take home here are this: if something didn't happen, say so. The court will ask you about it and ask you to fill in the details if they think it's relevant. If you do have a fact finding hearing, know that if you show insight, your ex is only ever going to delay contact. It's a stalling tactic. It's unlikely to stop contact. I hope this helps.